Essay: Gun Regulation. When it comes to the issue of Second Amendment rights, conservatives who oppose regulations on guns are hypocrites and deceitful. These conservatives clamor gun regulations are unconstitutional. Any restriction is seen as an abridgment of our God-given rights, but conservatives over the years have not been averse to regulating other constitutional rights. For example, conservatives have supported restrictions on freedom of speech. During World War I, several Americans were incarcerated for opposing the war, including noted socialist Eugene V. Debs for saying rich people start wars, poor people die in wars. Conservatives have supported placing restraints on religious liberty. In 1960, Roy Torcaso, an atheist, was denied a job in Maryland for refusing to declare his belief in God. In other states, conservatives enforced laws requiring public school students to say Christian prayers. Conservatives have supported restrictions on freedom of assembly. The House of Un-American Activities Committee was allowed to ruin the lives of Americans who associated with leftist organizations. The Smith Act, passed in 1940, was used to prevent membership or affiliation with leftist groups. Conservatives have even saw fit to regulate the sexual activities of American citizens. The Comstock Law was passed in the late 1800s and was still being enforced up until the 1970s in several states to prevent married and single women from using contraceptives. As late as the 2000s, several states had laws prohibiting gays from having sexual relationships. Conservatives do not have a problem regulating abortion. Several states have passed laws requiring women to wait 24 hours for an abortion after consulting a doctor, to view the fetus, and to inform their husbands about their intention to abort. This last stipulation was declared unconstitutional. And yet, conservatives want us to believe if any regulations are imposed upon our Second Amendment rights, it is a result of a tyrannical government. It is clear these people have a political agenda. It is also obvious that these same people have never studied the history of the Second Amendment or the activities of the Founding Fathers. For if they had, they would realize the Founding Fathers strongly believed in regulations. During the age of the founding generation, the most sacred of rights, voting, was restricted. In many states, the common white man had to meet property and tax qualifications in order to vote or hold political office. And just as voting was regulated, gun rights were regulated at the federal level and in various states. For instance, the Founding Fathers wanted to prevent law-abiding white men who refused to pledge loyalty to the Revolution from owning guns. In a 1792 federal law was enacted requiring men to purchase guns, to have their guns inspected, and to register their guns on the public rolls. States always had the right to regulate an individual's right to own firearms. Supreme Court decisions of Barron v. Baltimore, 1833, and Presser v. Illinois, 1886, made this clear. Some states prohibited the carrying of concealed weapons. Some states prohibited Jews and Catholics from owning guns. In 1939, a conservative Supreme Court ruled in United States v. Miller that the federal government could regulate firearms. In 2008, another conservative-dominated Supreme Court ruled in District of Columbia v. Heller that while individuals had rights of owning certain guns, this does not preclude the federal government from regulating guns and restricting the use of others. At no point did the Supreme Court rule in Miller or Heller that an American had unlimited rights in owning any type of firearm. And when conservative gun advocates make this claim, they are lying. It must be understood, the Founding Fathers did not create a document with absolute rights, meaning no right in the Constitution is beyond regulation, and this includes the Second Amendment. As citizens of the United States, Americans have the right to own certain firearms for self-defense, but this right does not curtail the power of legislatures to regulate guns used for personal protection or to prohibit certain guns from public use.